that's the abstract of the law. I'll say little about presentation of evidence, because I've attended court very occasionally, having then attended court, given evidence only very, very occasionally. And after I wrote that, I then had to give evidence remotely from my office in the universities to Snaresbrook County Court. So the attendance at court was virtual then, and I gave the evidence remotely, which I gather is something of a bit of a novelty within the English legal system. Anyway, what I was going to talk about more is initial approach by lawyers or police to submission of a final report. First of all, how you get involved with being an expert witness. It happened to me basically when somebody walks in, or not quite off the street, but he had a problem. He was a forensic odontologist, and he wanted some advice about actually background data and how to analyse it. And then that was as a PhD student, and then I got a job in the University of Strathclyde, which had a forensic science unit, and I became interested in forensic science, resulting from this dental case, and talked to the forensic scientists there, and one of their members of staff, Jim Robertson, was very interested in statistics, so it sort of went from there. And I wrote one or two papers. Then gradually people got to know that I was interested, and it went on from there. But we had in 1985, we had a seminar in the department, I was then in Edinburgh, about DNA profiling, this new technique for identifying people with great uses in forensic science. One of my colleagues said to me at the time, at the end of the seminar, I said, well, Colin, that's you out of a job. Basically, DNA profiling would solve all the problems. Little did he know it was quite the opposite. Anyway, so what happens in my case, you've either got the police will phone up with a problem, or a lawyer will phone up with a problem from the defence side, or the Crown Prosecution Service in England and Wales. And though I'm in Edinburgh, most of the work I do is actually in England and Wales. I don't get so much from the Crown Office in Scotland. And then, if the police are asking you, that's something to do with investigation, you're sort of helping them as investigating a crime. And you've got a duty to be impartial, but you're going to be writing a report for the police. If it's the lawyers, the solicitors, the CPS, if you're going to be an expert witness, then you've got a duty to the court, irrespective of who is instructing you. And that certainly was interesting in one occasion where I thought the witness didn't give his evidence well, but it was not very great. But the defence counsel was pretty hopeless and didn't ask the right questions. And I was asked as a professional misconduct hearing to write a report. And I wrote a report. And in that report, I criticised the defence counsel, who brought a phone call from the solicitors, or the solicitors involved, saying, what we're doing is nothing to do with the defence counsel. We're going to take that bit out. Or you want to take that bit out of your report. All right. Just want me to write about the witness, that's what I'll do. But then, when it came to giving evidence, this is one occasion I did give evidence, and the defence counsel acting for the expert witness and the professional misconduct case, do you not think this is a matter of the defence counsel didn't ask the right questions? And of course I would say, well, yes, I agree with you. So I don't know what the other side thought of that, but that was me being impartial. So, and then I've got an inquiry and they say, can you write a report? And the thing is, send me something in writing, some reports I can read, and I'll tell you whether I can help you or not. And then you can have a look at that. Now, I'm in a privileged position because I work for a university, so I get a lot of freedom as to what I can do. And I also have a university's commercial consultancy office that provides all the administrative backup to this sort of thing. So I can say to the lawyers or the police or whatever, well, I think, yes, I can help you. And then have to make an estimate of they ask, well, how long is it going to take and how much is it going to cost? The time element, there's a bit of a tension there because you can't undersell yourself. That's unfair to your colleagues, it's unfair to your employer at the university, and also, regrettably, if you come cheaply, you're viewed as being cheap. But then you can't do the opposite and oversell yourself, because then, well, you might not be able to, they might not take you on at all. But you also don't want to seem to actually be in it for the money. And the ones I do, generally always, I'm actually very interested and always do it for nothing, but that's not fair on a lot of people. But there is a desire to be helpful. But it is very useful. So the university has published consultancy rates, a certain amount for writing a report, and a bit more, not for giving evidence, for actually attending court. And I've been down to London for an appeal case, sat about in an appeal court and said at the end of the day, oh, we don't need you, Professor Aitken, you can go home in Edinburgh. It's bearable if you bring a good book or some work to do, and you know you're getting paid for it. You can get paid if you expect it. But in that case, I was actually able to listen to the other experts giving evidence. So that's an interesting day. But certainly, the university provides professional indemnity insurance. So if you really cock it up, you're covered for that. If the client doesn't pay, they will do the chasing, which is very useful. If the client argues about the fee, they will I'll just pass the button and say, sorry, it's nothing to do with me. I'm an employee of the university. And then, so you've got this instructions. You can get instructions from a solicitor. When there's a court case coming up, or the police are sort of interested in investigation, they'll come. Usually with lots and lots of data. One thing the police are good at is collecting data. I had one case where they had a CCTV image of a car registration plate taken by a camera on a bus that the car was passing at the time. And there's a partial image, and they're saying, well, what possible registration plates could create that partial image? I think there might have been thousands of them, certainly hundreds. But they went and checked every one of them and eliminated all bar one of them, which happened to be the one they want. But anyway, well, that led to I wrote a report about that. But the police will go and say, well, what data do you read? They're used to going out and collecting large data, which to me sounds large amounts of data, which to me sounds extremely boring. But what to do? Anyway, you write a report, and what I do, I'll get very nervous about this, but I write a draft report and say, what do you think of this? And it takes quite a long time of negotiations before I'll actually have a report, which I'm happy to to sign, but you can do it with face-to-face meetings, do it by phone calls. The police will quite often they'll come up to Edinburgh. They're asking me to help them, so they come to me. Last week in Cambridge, it was interesting. We were talking about came up with the idea of property and a witness, and it's different in England and Scotland. And I got asked by the defence of the case to write a report, and I thought it was too difficult. I didn't think I could do anything for it, so I said no. And about a year later, I got asked by the prosecution to write a report in a similar case. And that looked a bit more plausible, perhaps I had more time, so I said yes. So the QC came up from London, and he explained the case, and I said, oh no, I think I've been asked by the defence to write a report for this a year or two ago. And he said, oh dear, you're tainted. We can't use you. So this QC had flown all the way from London. He'd been in the room less than 5 minutes. I thought he had to go away again. Fortunately, I had a colleague down the corridor that was able to help. And then eventually I ended up having to write a report to the defence. So, then also while you're going, the time scale, they ask, how long is it going to take? Again, you can't say too long. Well, I don't like saying too long, because you might again put them off. But so usually I end up giving them a time and spending more time on it. What am I doing? Another 5 minutes or so? Yeah. Again, through the university, this is very flexible. If I do things like this, it has to get signed off by the head of school before I start. And again, in my department, the head of school is very happy to do this, because I'm about the only person there that has consultancy income. And this just ticks a box that he has to write to the high-ups in the university about how much consultancy the department. I think it might get a bit better now, a bit more statisticians. For a while, I was the one doing it. But you have to have a balance of time. How much time do you spend on writing the report? And that's one of your main university duties. So that usually ends up working in evenings and weekends. And sometimes you can get research papers out of it. Don't happen very often. You need to keep a record of the time spent, because you write a report, you submit it, the university submits an invoice, you get paid for that. Well, the money goes to the university, 15% goes to the corporate university, 15% goes to the school or department, 70% comes to me or the consultant. And the tax man takes a bit. But the finances are fairly straightforward. But then there might well be a follow-up, and they say, well, okay, if this will take me a few more hours, and this is a bit more, then you get a bit of a negotiation. The university has a standard consultancy agreement, expert witnesses. They sign that, not me. I check it to me, so I have to tell them who to send the invoices to, and so on and so forth. And just to finish, the sorts of things you have to sign as well as the report. You've then got this rather formal part. I've made clear which facts and matters referred to in this report are within my own knowledge and which are not. Those that are within my own knowledge I confirm to be true. They represent my true and complete professional opinions of the matter to which they refer. And of course there is the professional misconduct. These are the only times I get conscious of my chartered statistician status, and thinking if I really make a mess of this, this. Maybe the RFS will throw me out, but they haven't done it yet. So this is a witness statement of a whole lot of the Criminal Justice Act. This statement is true to the best of my knowledge and belief, and I make it knowing that it is intended. I shall be liable to prosecution. Well, that's a bit scary. If I willfully say anything which I know to be false, or do not believe to be true, I take great comfort in the do not believe. I'm saying, well, I didn't believe it. I thought it was true when I said it, but all right, maybe I've got it wrong. And there's also the caveats that if the circumstances change, if you're told more, you've got a letter, you'll change your report. So if something changes, if more evidence turns up, then you have the right to change the report. Just to finish, I think this was somewhere in the National Crime Agency documents, what an expert is. An evidence is intended to be put before a court with relevant skills and knowledge, research, experience, or professional application within a specific field. Give evidence upon their opinion, independent and impartial assistance. Experts are the only witnesses allowed to give opinion evidence. And once or twice I have given evidence, in fact, well, this recent case, under cross-examination, quite pleased. I think about 3 times I got the defence counsel to apologise. She made some statement, you think this, and I said, no, I don't. Oh, my mistake. So you have to be a wee bit careful if you're arguing evidence, not to, the other side will try to say, exaggerate, or something was minuscule. I said, no, it's not minuscule, or something significant. It's not significant. But, yeah. So, I think that's, we've run out of time. But some of the experiences I've had in writing reports and so on, I hope it doesn't put you off doing it yourself.
I kind of got into it. So I'm coming from the perspective, like Colin, of a full-time academic who's done some occasional expert witness work over many years. How you get into it, I don't have much to say. I got into it a sort of fortuitous way, but it was definitely connected to research. Somebody came along from the London Metropolitan Police Forensic Science Lab, as it then was, and gave a seminar on these newfangled DNA profiles. I have to question you about your memory, because I don't think DNA profiles were invented in 1985. I'm not, but in case that I think it was.
Alan Jeffreys was 1985.
Okay. Anyway, so sometime after that, there was a seminar from Matt Greenhouse from the London Metropolitan Police, and I actually missed the seminar. But one of my friends went along, and we talked about it afterwards, and discussions about the problems about statistical inference from these profiles, population genetics stuff, all of that, and eventually I got into talking to the forensic scientists there and got invited to speak at a forensic science conference on DNA profiles, and then some lawyers heard about me, so I kind of drifted into this. I've never had any training, and it shows, and it shows a little bit in the sort of disorganization, because I've got a sort of a bit of a rambling collection of thoughts from my 20 or so years of experience, and some of these things might be wrong, but the real professional is coming up after me, Tim. You do the training as well as other things, so he'll correct the things that I get wrong. But this is some of the... I've done a few reports in civil cases, but nearly all of my experiences in criminal cases, so I'm going to talk about that. Colin's already mentioned this. If you're in an academic environment, kind of bizarrely, when I started out years ago, doing consulting used to be considered like moonlighting because you've already got a salary and you're cheating, but it's completely the reverse now. I think it's gone madly in the other direction, that the government loves universities doing consulting because that's engaging with business, and so universities love you to do consulting, and they generally do good deals. When I was at UCL, I had a really, I thought, very good deal that they were very keen for me to do this. They took a 20% cut, and some academics complained about them taking a 20% cut, which is kind of mad because, you get a lot for that. When I was doing it on my own, it's really hard to get paid. Lawyers are the hardest people to get money out of. And so if somebody's doing the chasing up the invoicing, that's really good. And Colin mentioned the professional liability insurance. But the other really good thing, until recently, was that UCL were quite flexible, that you could channel the income, so the other 80% could be channeled as personal income or into your research slush fund as you preferred, and they've sort of made it clear that the personal research account could be spent at any purpose. So I channeled a lot of money into that, and just when I got a large enough amount that I wanted to use it to hire a postdoc, UCL changed its policy and didn't allow that. So this caused a huge fuss, and I mean, I really did the institution a great discredit to have cheated its employees on such a big scale, and there was a huge fuss about this and protesting academic board meetings and so on. And eventually they stepped back, but there was about a year in between when I'd left and it became too late, and so I sort of lost all of that money, although I'm still kind of fighting to get some of it back. But anyway, if your university, I think Colin mentioned the university takes 30%, at UCL it was only 20%. Anything in that range I think is pretty reasonable. So here's a few things that I've kind of gathered over the years. So one of the things you get from watching TV shows is there are, the TV crime dramas. There's always this moral dilemma about whether if you're working for the defense, you're getting off someone who's really guilty or something like this. But in practice, it's nothing like that. Whether the guy's really guilty or not is none of your business, and it's not something you should even think about. From the defense's point of view, the question is only, has the prosecution proved its case? That you've got to put them on the spot, because you can easily see that our civil liberties are down the drain if prosecutions can convict people without making a really convincing case. There are a lot of frustrations in the system. Much waste of time is kind of inevitable in a sense, because you're trying to get all these professionals together and the jurors as well. But there is, maybe for justifiable reasons, a lot of waste, because often courts don't sit until 10 or 10:30, and they sometimes ask you to come at 8:30 so you can, or 9, so that you can have a chat beforehand. And in some cases, it's clear that that's the first time they've looked at your evidence, and sometimes then they just say, "Oh, we don't need you," or something like this. And it is very expensive, waste of time. They may not use your evidence well, so just like you've got no business thinking about whether the defendant is guilty or not guilty. The whole kind of management of the case and how well they use your evidence, it's really best for your sanity to not think about that either, because it's the lawyer's job to run the case, and you're a tool in their hands. But it's also on the frustration side. Despite what I've said about in principle, it's not the defense's job to get the guy off the hook. In practice, of course, they get judged by getting people off the hook. So there's a certain amount of that, and of course, when it comes to scientific evidence, the defense potentially has an interest in obfuscation, not always, and that can be very frustrating for the expert witness. I mentioned here about sort of careless or flippant email. I get a bit of a shock because you sometimes, I'm working with forensic scientists, and I sometimes email backwards and forwards, and sometimes they're sort of very brief emails. But one time I got a bit of a shock when some of my emails were read back to me in court, and I didn't know even that they'd been disclosed. But of course, as I say, potentially anything can be disclosed. So careful about doing careless emails. So it's challenging work. You've got to be on top of all the paperwork, and there's quite a lot of facts to keep in your head. There's a tendency on the part of the lawyer to send you everything, which is a bit of a sort of defensive mechanism for them, because then it becomes your responsibility to comment on it or something. So you've got to guard against that. And in general, and of course, so this question of what's relevant to you is important. You've got to make sure they don't send you everything. When I started out, they used to always routinely send me every gruesome detail of the crime, which are often pretty horrific. And fortunately, they don't do that anymore, although I've just done a case in Australia, and they still do that in Australia, which is, it's completely unnecessary. Generally, you don't need to know many details of the crime. Obviously, it's a little bit hard to judge relevance, and so I don't have any good principles, but I think the less you know, the better, in a way, because so you might you know, you might hear that there's other mobile phone evidence which is very strong, and that might put you in mind, you know, that might create a bias. You think that, oh, well, he's guilty anyway, or something like that, you know. So I think it's just better if you don't know that, if you're not the mobile phone expert. You know, these things are difficult to judge. But anyway, whatever you do read, so if you're sent something, you don't necessarily have to read it if you decide that it's not relevant, but, you know, then you need to state what you have read in your statement, because that's quite important, what you're relying on. So I think Tim's going to say something properly about how to write reports. I've just got a few sort of top-of-the-head comments here about, you know, there are certain things. I always state that I'm a chartered statistician. I think it's just standard that you state all your qualifications. I don't think anybody's shown any interest in me being a chartered statistician, unfortunately, but maybe if I hadn't stated that, there might have been some question. But certainly, you know, and you know, all the details of what information you had, who gave it to you, and so on, those kinds of things, and of course, to state what you've been asked to do. So that should be kind of clear at the outset. You know, that when you've written this report, and some later date, month, you know, potentially months or even years later, you can get put on the spot when you ask, you know, you're asked about the meaning of a particular set of words, and then you realise that, you know, you worded that a bit vaguely or unclearly or something like that, you know. So all of those things really, to some extent, get learned on the job, but it's difficult. In general, of course, you shouldn't comment outside your expertise. It's hard to do that, though, of course, because we're statisticians are kind of professional busybodies, right? We have to know everybody else's business in order to do our job, and so it's hard to get that right as well. But to some extent, you know, I've certainly had occasions when I've been asked questions and said, look, I can't answer that outside my expertise. Sometimes, of course, you get to comment on the report of another expert, and naturally you have to be critical. That's the name of the game in an adversarial system. But obviously, you should try and keep your criticisms, you know, relevant and properly stated. And qualifications of the other expert is a relevant thing for you to comment on, and I have sometimes commented on that, and sometimes said that I don't think the other expert is appropriately qualified, and it's often because there are scientists of some description without appropriate qualifications in statistics. Unfortunately, judges and lawyers seem to have little interest in this, in my opinion, but occasionally I think it does get picked up. But sometimes I've made quite detailed arguments that the other expert is not qualified, and they usually don't care. And I mean, you have to give a bit of leeway that it's very hard to get experts, and defences sometimes, you know, don't realise what kind of expert they want, and they can't get anybody else if the defence doesn't have an expert at all, possibly. I mean, I did hear a comment last week about a trial that collapsed because the defence wasn't able to obtain a qualified expert, and the judge refused to let the trial continue. Anyway, there are all these issues too. Not that any of that's really your problem, but it's part of the picture that. There's a few things about what goes on in court. Of course, the main thing is this general restriction to answer the question, which can be quite frustrating because they often don't ask the right question, and you have a little bit of leeway. I don't exactly know the rule. Tim might know this, but I think an expert does have the right to say, look, there's some important stuff you haven't asked me, and I have done that at the end of my evidence, and they seem kind of happy with that. But in general, you can't speak up on your own behalf, and particularly when you're being questioned by an opposing barrister. Of course, sometimes they can be a little bit hostile or aggressive. In general, in Britain, in my experience, it's usually not too bad from that point of view. That I think one of the worst things an opposing lawyer said about me, that we were talking about in the early days of DNA profiling, about whether frequencies of DNA variants might vary around Britain. And the crime, I think, was in Burnley in Lancashire, and it was in Liverpool Crown Court. And the opposing barrister asked me, Professor Bowling, have you ever been to Burnley? And actually I had, but I got it wrong, and I said, no, I don't think so. And then I heard him later summing up to the court, and he said, well, we heard from the professor from London, but he hasn't even been to Burnley, so what could he know? And but generally, I've been treated politely. Sometimes you get this kind of repetitive question thing, but Let's see. So what generally often goes on is in court is that you kind of sit behind, you sometimes get asked to sit behind the barrister while the opposing expert is giving their evidence, and you can pass notes and so on and give briefings, and that can be a kind of relatively interesting part of the job, but it's quite hard to kind of to get all that right. But the interesting part for me is always the best part is the case conference in chambers. Then you're invited in with the lawyers and perhaps some other scientists involved in the case, and they treat you like an important person, which is always nice, and they listen to you carefully and give you the impression that they've understood what you say, and then we get in court, and then of course it's clear from their questioning that they don't really understand your point, and of course you're not allowed to say, look, I told you that, you idiot, because you probably get into trouble for saying things like that. But so it can be a little bit frustrating. Let's see. So most of us nowadays working so I'm working with forensic DNA evidence mostly. I've been involved in a number of other cases. So the whole kind of Bayesian paradigm is quite useful. I'll say a little bit more about how that works with DNA evidence in a moment. I won't say much. There have been some famous judgments in the UK, and the UK, England and Wales Court of Appeal in particular, has been kind of getting kind of worse and worse in terms of judgments and disallowing any quantitative evidence and also there are some judgments about not allowing explicit Bayesian reasoning. Now the meaning of all that is a little bit subtle, and how that kind of plays out in it can depend a little bit. It's up to the judge in the present case, and I've often given evidence in a kind of Bayesian way, and judges have sometimes been happy with it, and sometimes they've been not. Of course, I never put it explicitly like that. I talk about I'll tell you a little bit about the sorts of things I say in a moment. I've never found much role for. Let me make this point first, because there's an important one. It's often made, and it's actually a good point, that with DNA match probabilities being so low, the low value is, in a sense, irrelevant, because it's so low that even if you think the system is completely honest, the probability of some kind of fraud or gross error is probably much higher than the probability of a chance match, and therefore the probability of a chance match becomes kind of irrelevant. And I think it's a valid argument, and it's probably true, but there's not really much you can say quantitatively about the possibility for fraud or evidence tampering. You can certainly point out that that's a relevant factor, but you can't quantitatively assess it. And so I think it's reasonable for you to limit yourself what you can quantitatively assess, and just say there are these other factors as well. And now the whole sort of classical, and I think a lot of statisticians get into trouble in this area because of thinking in classical statistics about null hypotheses and p-values. It doesn't really work in the context of a criminal trial usually. That what is your null hypothesis? There's usually some kind of, with DNA evidence, the null hypothesis is some kind of something about random choice in the population and so on, which is a phony hypothesis and problematic for a number of reasons. There's a controversy to some extent about the likelihood ratio, which is the standard measure of evidence. I'll just come to that on the next slide, but whether you should have a confidence interval for that, and I think a sensitivity analysis is more appropriate. There's a lot of opinions on that. So this is more or less the kind of framework that most of us. I'll tell you a little bit in the end. There's a workshop on probability and statistics in forensic science at the Newton Institute in Cambridge at the moment, and some of the people at the front here are at that workshop who have just taken a little break away from Cambridge to come to the conference. And most of us are kind of working more or less that the generally accepted way of measuring the strength of evidence in a criminal context, at least, is this likelihood ratio that measures the probability of evidence given some prosecution hypothesis and the probability of the evidence given a defense story. And it's not always, there are other complexities, but often the DNA evidence, the key parts of the story is who are the contributors of DNA to this sample. So we might have some hypotheses about particular contributors, and under the prosecution hypothesis, there's a particular individual that I denoted Q for the query contributor, and in the alternative, that's replaced with some unknown individual. There are some real problems, although this is a very, very useful framework for thinking about strength of evidence, there are some real problems associated with this, and for it to be kind of fully valid, that, so basically the defense is not obliged to propose any story, and even if they did propose a story, in order to prove the prosecution's case, whatever the defense say, the prosecution has to negate all alternatives, not just any one alternative. And typically there are many alternatives, and so in the context of DNA evidence, here are some of the sorts of alternatives, as well as all of these issues like, well, yes, it's his DNA, but it got there by some innocent means. Strictly, then, in order to implement this paradigm, you need to add up the denominator over all the alternative scenarios, but that will involve some kind of weighting according to your prior belief in those different scenarios, and that may be something that's not appropriate and not the judgment is not appropriate for you to make. So there are sort of fundamental difficulties there. Typically, in DNA evidence, there are at least two important scenarios, that if it's not the defendant, the two important alternatives are that it's a close relative or an unrelated person, so you can just present likelihood ratios for both those alternatives and then possibly some illustrative calculation to try and suggest how they should be used. So there's some interesting stuff. Now I'm getting to the point that Roberta is going to get me to sit down and keep quiet soon, and I've still got a lot to say. There's a lot of interesting stuff. I'm just getting up to about how you deal with these two competing stories kind of idea, and it's become clear that some of us are approaching this in some different ways. The traditional way of thinking about it, that I'm just calling the legal approach here, is that there's a likelihood ratio is two competing worlds that are quite separate, and all the estimation and elimination of nuisance parameters should be done separately in each of those worlds. And so the dropout rate under the prosecution scenario has nothing to do with the dropout rate under the defense scenario. But some others work in a slightly different way, where essentially they estimate everything under the defense scenario. So I call that the kind of scientific perspective. Well, we don't know, so we take the more general proposition and estimate the parameters and eliminate nuisance variables here. And then assess how consistent that is with the prosecution case. And these two different approaches have quite different implications, and they end up with different stories. And I think that's the kind of interesting topic that I haven't really got to the bottom of yet, about what are all the implications of that. How to use likelihood ratio in court? Well, that's sort of problematic as for reasons I've been given, but I have got away with giving illustrative calculations like this. Some judges have found it quite helpful. Some people suggest that it's problematic because, by even suggesting a tentative starting value. So, but I generally give several of these. So it could have been any one of 1,000 men. Therefore, if they're all equally likely, there's an implied prior of 1 in 1,000. So the likelihood ratio takes you from 1,000 to 1 against to 1,000 to 1 on, and then you can try with different starting values. I found that quite helpful. And for example, one case I was involved with, there was a gang of 10 men, and I was told that I could assume that suspicion, it was only one of these 10 men that the DNA could have come from. And so even though the likelihood ratio was only 200 in that case, I was able to say, well, if members of the jury, you accept that it's one of these 10 men, then 200 is a pretty good likelihood ratio in distinguishing one of them. Not completely convincing, but it's very strong. But
did you exclude the others? Was there no evidence that the others didn't match?
No, we didn't have profiles, so there were 9 unprofiled of those 10. But it's just a question of the pool of possible suspects was only 10, rather than, in all of Liverpool it might have been 500,000 or something. All right, I've got a minute or two more, I think. No, I'm eating into my time. Let's see. There's some interesting stuff about, whether these words used to describe likelihood ratios and how useful they are. I don't have time to discuss that now, but I find them useful, but always report them together with the likelihood ratio. Some people prefer to use the words and hide the numbers, which I would never do personally. Yeah, it's an issue about reliability of evidence. Of course, software validation, if you're using software at some point, if you've written your own software, it used to be, not too many years ago, that you were considered the expert, and by extension your software was expert software, and it wasn't questioned too much. But all that's gone now, that you have to have proper sort of validation documents, and everyone's in a bit of a quandary about what constitutes validation. That's another big topic that I could give a big talk on. All right, I've got a few little anecdotes around the end. Let me just see that I think I'll skip that one. I always remember the one when likelihood ratio was 50, and I was trying to say that's not a very strong likelihood ratio. The judge was horrified because he thought 50 was strong, because he said if horses 50 to 1, you can be pretty sure it's not going to win. So it was hard to know how to. There was a case in Oxford where we got into really nitty-gritty about this question of how you eliminate nuisance parameters, and the defence expert was insistent that there's only one value for the dropout rate, and it must be the same under both the defence and the prosecution hypothesis. And that didn't really make sense, because it's frustratingly difficult to have that argument. But of course, this is a debate beyond most undergraduates, let alone a kind of lay jury. So what they made of it, I don't know, but they convicted the guy in the end. That's all we know. But I'll skip that example, which is an interesting one. There's a little bit about there's a 5-month program at the Newton Institute, which was started a month or so ago, but in particular, there's a workshop on statistical modelling of scientific evidence about the second week of November, and officially registrations are closed, but informally, if you contact me, I think it'll be possible still to attend and read my book. But thanks, everyone.
I'm sat here with stood here with my barrister's hat on today. So I ought to really tell you about, if you're thinking about becoming an expert witness, what you're getting yourself into, really, because you're getting yourself into a very difficult area with a lot of onus placed on you. Basically, I just want to quickly go through, we'll just see how far we get, but basically, expert evidence plays such a pivotal role in many areas of the law that it's hard to just pin them all down. But for the purpose of today, I'm just going to focus on the criminal law of England and Wales. And if you want to have an overview of the area, get the Law Commission report, which was done in 2011. So here's the issue. The courts invest great faith in their experts, and so they really want to be sure that the information that you're giving and what you're doing is reliable, okay? Because there have been some very public miscarriages of justice through faulty expert evidence, and so there's a big onus on you and what you're doing. And so the big issues are, we need to ensure the quality of the experts, understand how they're getting their results, how they're interpreted, how they assess the weight of the evidence. And the lawyers tend to refer that as the reliability of expert evidence. And they also need to make sure the experts follow some very strict ethical standards and observe professional duties. There's the kind of generic model of the expert process. You usually got the expert running some kind of technique or method in some environment with some examination standards, generating data, interpreting that data, either giving that as a technical report, in other words, how much alcohol per millilitre of blood, or doing some kind of comparison with a footwear mark or a DNA or glass or something, evaluating the weight of evidence in relation to the background data and the hypotheses in the case, and then rendering some opinion, and all that's packaged in this cloak of the duties of an expert. Okay, and so the quality of expert evidence basically depends on the totality of that. All those steps in those boxes have to be sound, otherwise what you've got is a flawed process. And so the courts want to know that they've got somebody who is actually expert, that they're using valid methods and techniques, that there have been proper standards applied where there have been examinations, data's been interpreted correctly, weights have been assessed correctly, and that they understand when they lack data or prepared to change their views if the circumstances change. Okay, and when you get to trial, any or all of those boxes are fair game. You can be challenged on anything, and it doesn't matter whether you're instructed by the defence or by the prosecution. The game's the same if you're an expert witness. Okay, there are lots of different categories, and that means it covers everything from medics and psychiatrists, what I'm calling scientific things, technical things, and we even have experiential expert witnesses. What's the price of heroin in the street, betting systems and various other things. So you can have people who are highly qualified surgeons right down to Danny the bookmaker from the market. Okay, and I haven't got time to go through them, but there are lots of different things, medical, psychiatric, the scientific ones, the classic ones like DNA, tox, drugs, paint, accelerants, some of the more niche ones like geology, palynology. But these are all need standards and need appropriate levels of qualification. Some of these are more technical. In other words, if you're using an applied skill, then it's not so much about your academic standards, but it's about your technical skills, your ability to do the job. Okay, so it's very unusual to find fingerprinting people who have got degree level qualification and things like that, because it's a very applied skill. Okay, and so the pattern matching disciplines have a very large applied skill element to them. And again, you can get these occasional experts who are just on, can be the most obscure things. I've even had a case where they had an expert in from Isuzu who was talking about aftermarket modifications on an Isuzu Trooper and how likely they all were to occur together. Okay, and that kind of expert might have little appreciation. But if you're going to be an expert witness, you have to understand the system, and everybody who comes through our organisation has specific training in how to be an expert witness and the rights and responsibilities that they've got. So in order to keep that system reliable, then we've got to look at all the totality of what we're doing. We need overarching standards, we need showing the competence of individual experts, being able to demonstrate validity of methods, keeping a set of standards for certain types of things, about how we control what's in reports and how they're done, and their disclosure rules, and that's how the legal system regulates it. The control mechanisms come via a variety of ways, some of it via legal means, primary legislations, Criminal Procedure Investigations Act, Criminal Justice Act. The main thing are the Criminal Procedure Rules, 2015, Part 16 and 19, which covers expert witnesses. There's a lot of case law called jurisprudence around the behaviour and what's required of experts, and there's also criminal practice direction. And there are lots of stakeholders who are regulating you. Judicial Studies Bar, the Bar Law Society, Ministry of Justice, CPS, and the Home Office Forensic Science Regulator now. So there's a regulator who looks at some of the quality issues. Your governing bodies, whether it be a chartered or the GMC or whatever, may have rules about about your conduct as an expert witness. And ultimately, the courts decide whether you're an expert or not. So the duties in place are spread out all through case law, but they've now been handily codified into the criminal procedure rules. And particularly, there's also the forensic regulators issued a code of practice, and everybody's expected to follow that. And if you're instructed by the Crown, the CPS also place additional burdens on you, something called Annex K of the CPS rules. Basically, it places extra duties on you to do various things about recording what you're doing, retaining it in a durable format, and then disclosing it to when you're required to do so. And there's various things called the Experts Index, the Self-Certification of Expertise, and the Declaration of Impediments. So here's one of mine. You have to basically say that you're an expert and what the expert's in, and then there's a kind of sheet that you have to fill out where you have to grass yourself up if you've ever been found guilty of this or guilty of that, or whether anybody's made any negative comments about you. Okay, and it's all personal information, whether you've been sued by your wife or whatever. It's really quite extensive. Here's the code of conduct, which I'm going to let you read and crack on really quickly because we're short of time. Your duties to the court and the administration of justice, not to the person instructing you. You need to be independent and impartial. No conflicts of interest should be apparent. You need to stay well within the confines of discipline, or that can have some blurry edges sometimes. You need to make show and be able to maintain your professional confidence. Look after any exhibits that come into your possession. look outside what you need to do and make further inquiry where you need to. Only use validated methods. Revisit your findings if you get new information. If you feel something's gone wrong, you have to blow the whistle, and you need to keep stum, keep quiet unless the law compels you to disclose or tell somebody about something. You're expected to be all those things drummed into our guys, balanced, objective, impartial, independent, reasonable, fair, honest, transparent, professional. Those are the kind of attributes that you'd expect a expert witness to have. Question over there about competency. Easy word to say, difficult to define. Who decides who's competent? Actually, the judge in a trial has got a special role called the gatekeeper role, and he will ultimately decide, in your case, the gentleman over there, whether the other guy without statistical qualifications is a competent expert for that area. So if the barrister in your side takes a point and says, we don't think that gentleman is appropriately qualified, then the judge can decide the matter. Okay? If he does apply, look into that, what test will be applied? Well, they apply something called the Bonithon test, which is a South Australian case stated. But basically, it's a 3-element test, which I haven't got time to go into. But basically, he's going to ask questions which will shed light on those 3 things. Okay, it's basically, has the witness acquired, the main one is going to be, by study or experience, sufficient knowledge to render his opinion valid to resolving the issues to this court. The Law Commission proposed a statutory test, but the government hasn't taken that up, so we don't need to worry about that. If you're being challenged about your expertise, what kind of things could they challenge you on? Again, I haven't really got time to go through all those because of the time limitations. But they can test you about your academic, professional qualifications, whether you've had any extra training, your length and breadth of experience, whether you've done any formal research, whether you've made any formal publications and writing, your standing in the community, whether you're subject to some kind of evaluative system, and whether you're a member of a professional body. Those are all things that bear on expertise. There are other things which assure experts are exactly that. There's a whole regulatory apparatus that bears on me the whole time when I'm giving evidence as an expert witness. Our labs have to be accredited. There used to be a registration system, but that's gone now. But the forensic regulator will look at individuals as well as organisational competency. It's a multifactorial question of whether you're competent or not, but it needs to cover the whole gamut of witnesses from the pathologist who's done it as a day in practice to the occasional expert. It's not just about academic or educational attainment. And the more applied the skill that you're talking about, the greater the need to demonstrate actual practical competence. CV, no good having 1,000 publications on a CV if none of them are relevant to DNA or forensics, if that's what you're giving evidence about. In the US, there's a far more formal inquiry into your competence. It's called a Frye or a Daubert hearing. We need to make sure that we're using valid techniques, and a lot of arguments at court about whether techniques have been properly validated and they're standing in the community. The recent proliferation of DNA techniques has driven this, and the onus will be on the person seeking to introduce the evidence to demonstrate that they are using a valid technique. Ultimately, the court get to make that call, or whether or not it's a valid technique. Roberto, I think we have to stop now, don't we? 5 minutes, okay. There's no simple statutory test for what's a valid method. The US have this Frye standard or Federal Rules of Evidence 1702, and they talk about something that's generally accepted in the scientific community. Here, it's really just down to the trial judge who will decide, having heard evidence, usually in a voir dire, which is a trial within a trial, whether or not the technique that's been wanted to be introduced is valid or not. And he'll look at these kind of factors. Again, I haven't got time to list them all out. You can probably read them faster than I can say them. But there are lots of things he could look at about whether formal validations of programs have been done. If they have, whether they follow some kind of industry standard, whether it's been published in the academic literature, who's looked at it, when have they looked at it, has it been subject to negative criticism, has it been rejected by any other jurisdictions or bodies. And there's quite a lot of things that can take into account whether the technique that you're seeking to introduce can be deemed to be valid or not. You're expected to follow standards. This is really not for statisticians, but it's more people who are doing hands-on comparative work. You've got to make sure you do lots of things when you're handling exhibits. You have to have full records, photographic and notes. Keep the continuity of the exhibits. You have to follow anti-contamination protocols when you're doing trace evidence. You have to have systems in place to make sure you can't switch samples or evidence. You need positive, negative controls if you're doing testing, quality control, consumer-related, calibrated equipment. Always have your work reviewed by a second person. Absolutely key. You should get your work reviewed by another competent person. It's part of the central quality assurance system. And really, if you're being serious, you ought to subject yourself to QA trials as well, quality assurance trials. When you're interpreting evidence, there's always going to be room for manoeuvre, and experts will disagree. That's why we have experts, because it's not always clear-cut. Okay, just because two experts disagree doesn't mean one of them's wrong or one of them's incompetent. Okay, and the cases can turn just on nuances of interpretation, but peer review does increase robustness in that part. Okay, so when you're drawing an opinion, David introduced this. We've got this forensic paradigm. You've got a trait X, the latest source is trait X, and if you don't know something about how often that might occur in some other area, it's hard to assess the probative value of that unless you've got some idea of the significance or the weight that can be done that. Some disciplines use numerical statistical assessment like DNA. The vast majority of disciplines aren't statistically based, and they just use expert judgment based on a standard verbal scale. We haven't got time to get into the whole debate about underpinning those with statistical work. So the guidance for the contents of your reports are in lots of disparate bits of case law. Mainly it's in statutory form in the Criminal Justice Act. The Criminal Procedure Rules also does it, and the CPS give you guidance as well. You've got to make certain formal declarations, and it also tells you about the structure and content of your report. Colin showed this. You've got to make certain declarations and statements about being liable to prosecution if you state anything. You've also got to say things like at the bottom there that you've had peer review done, and also if you've got a duty to carry on and comply with that duty. The structure and the content, you're supposed to set out who you are, your background, qualifications, say what you know about circumstances, what the purpose of your work was, what instructions you were given, say what you did, what results you got, conclude it and summarise it, put in any appendices and references that you need to. And the CPR goes into unexpected detail, which I haven't got time to go here, about what needs to go in an expert report. So if anybody was going to go there, you need to get the criminal procedure rules. There are also disclosure rules. If you're working for the prosecution have this duty of disclosure to the defence, okay, and therefore you need to tell the prosecutor everything that you've got in your possession, so he can make a judgment whether it should be disclosed to the defence. And then you have to provide one of these, which is called a disclosure schedule. If you're working for the defence, there's no reciprocal duty on the defence to disclose. Okay, that is a bit arguable whether there should be. If you're an officer of the court, then perhaps they should all be open. Okay, and the defence can sit on a report that doesn't help them, even though it might actually implicate their client, and that doesn't seem right to me. Okay, last couple of slides. If you're going to court as an expert, you'll be warned. You'll have to give dates to avoid, which can be a nightmare professionally when you've got lots of things in your diary. You won't be able to get out of it. Short of dying, you will not be able to get out of attending court. Okay, you're often placed on standby. There are floating trials and batting orders, and generally you can be told on a Monday you're needed and end up not here until a Friday. When you get to court, it depends who you're talking. Careful who you talk to. Often you're sat in the police room, so you don't get yourself in any bother. Switch off your phone. Okay, you'll have to swear the oath or affirm. And then a lot of the judges, believe it or not, still take hand notes, so make sure you go slowly so that the court can, even though they're taped. Proper terminology, again, this is all part of the training. People are suspects prior to charge, defendants after charge, etc., etc. Barristers are counsel, they're not the briefs. The officers should be given formal names. And I very often hear people, there's also terminology regarding the judge as well. Okay, hearing, you'll basically follow the same thing, which is you'll have an examination in chief, then you'll be cross-examined, re-examined. The judge may ask you questions. You can be part heard, which means you don't finish your evidence, in which case you can't speak to anybody over lunch, let's say. You'll often be given exhibits to identify, and the jury will often have a bundle, and you'll be asked to turn up certain pages in that bundle and talk about various things. Once you finish, you might have to sit in while another expert's there. You need to keep records and receipts if you're claiming professional fees. Sorry about that. 10 minutes, that was an absolute canter.